What's up, everybody, and welcome to another episode of Trial by Media, Fair or Foul. And today we are going to be looking into a witness's rights throughout the trial. What's fair for a witness, especially when it comes to media attention and social media activity by that witness? We have literally seen cases together on YouTube where witnesses have been thrown off the stand because of things they've seen in the media and on social media about the trial that they were supposed to be a witness in. We've seen witness intimidation. We've seen witnesses that we feel like have catered their testimony based on the pressure of the outside world and especially the media. So today we're going to talk about all that. We're going to talk about what their rights are, how we think it should go in the future to protect these witnesses, protect the fundamental fairness of a trial, the truth of the testimony of what a witness has to say. And to help me do that are both my partners again, Pete Sardis and George Tragos. We're back at it today, guys, and we are focusing on witnesses at trial. So as we just kind of talk about the right to a fair trial and making sure we have a fair trial despite media attention, what rights do witnesses actually have? Because they're not parties to a case. They're not law enforcement. They don't work for the state. I mean, some witnesses do if we're talking about law enforcement witnesses, but even lay witnesses, what rights do they have in this process?
Well, they have a right not to be intimidated. They have a right to testify. They have a right not to be harassed on the stand. They have a right to, I guess, some common decency when they're showing up and the timing and the scheduling of their testimony. They have certain rights to be treated fairly and with respect, just like any human being would.
Yeah. Can I hop in on that one, Peter?
Yeah.
The only one that's got a right as a witness is somebody that has a right against self-incrimination. I agree with George that all witnesses have or at least should be treated with dignity and respect. But when it comes to their ability to testify in court, they don't really have many rights per se, meaning that as a witness, you don't have the rights of a defendant. You don't have the rights of, unless you're a law enforcement officer, you have some specific limitations on what can be done for you. They can compel a witness to come and talk and speak in court whenever they want.
Okay. Well, we've got to also compare two kinds of witnesses. There are some specific rights that victims have as victim witnesses that by statute, we've passed some laws in Florida, in fact, constitutional laws that protect victims and give them certain rights as well.
So we're gonna talk about victims' rights specifically. We're gonna talk about that in another podcast episode, completely surrounded by that. I think today, if we're going to make distinctions, I think we can make distinctions between professional witnesses, law enforcement witnesses, and then lay people who are fact witnesses who just happen to be somewhere or knew somebody or saw something or their restaurant security camera picked up a car driving by, right? Talking about those witnesses specifically and how the media can affect them. Do they have rights to, I don't know, fend off pressures by the media, requests for interviews by the media? What do they have to do if they're a witness, especially if it's public record? If a witness list gets filed and the media sees, okay, John Smith is a witness in this case, what rights do they have as far as fending off the media and the attention that may come from a high-profile case?
Well, they really don't. The media has the right. They can go, they can try to interview them, they can try to talk to them. They have a right not to talk to them. They have a right not to be interviewed. They have a right not to give comments, but they can't stop somebody from asking a question. They can't stop somebody from approaching them.
And Pete, if they did feel like they were being harassed by the media and didn't want to talk to the media, what can they do to try to stop that?
At that point, the best bet is to go to the judge and ask the judge to make some sort of a ruling. And I'll tell you, we see it all the time. Like, somebody becomes a witness in a case, all of a sudden every news camera is out on the street in front of their house with cameras pointed at them and, following them around wherever they go. But if you ever notice, the media is not allowed to, they're not allowed to falsely imprison somebody. So they can't, corner you into a place where and force you to talk. They can't batter you. They can't grab you and stop you. But they have every right to ask you whatever questions they want to ask. Now, whether you answer or not is a different question. They can't, set up a tent on your lawn, but they can sure as heck set up a tent on the public street in front of your lawn. So really, when it comes down to witnesses feeling like they're being badgered, which is really the issue, the court is the only place that's going to be able to give them any redress.
And the way you get to the court is whichever side is calling you as a witness, you let them know what's going on. You let them know the media is pressuring you. The court is not going to look kindly on that. Will admonish the media could potentially lead to a gag order or some limitation on media talking to witnesses. So the media shouldn't want to do this. But if this ever does happen to a witness, they notify the state, for example, if they're testifying for the state, or a defendant, where the criminal defense attorney can let the judge know the media is pressuring, intimidating this witness. It's got to stop, or else it's going to violate the defendant's right to a fair trial. Have you found any cases or had any cases in your careers that a witness has refused to testify based on either the media attention, social media feeling about a criminal defendant or a witness, or a civil defendant or a civil plaintiff in a case? Have you seen anything like that?
Well, what you see mostly is, yes, it is the media attention they don't want, but what they don't want is their picture, their name, those types of things to appear in the media. And then for somebody who wants to do violence against them, getting that information, seeing their name, their address, and their picture, and then doing some harm to them. So that's why they're scared of the media, is they're scared of the media and what repercussions could come from the publicity they're getting. Or if it's a highly political kind of trial with a lot of those kind of overtones, then they're scared about certain groups coming after them if they find out that they're a supporter of a particularly one side, so that the other side comes after them and harasses them.
Pete, anything to add?
Yeah, not really. I mean, the truth is there's no real case that says I'm a witness and I refuse to testify because the media is going to be there, because most of the appellate work that the cases that we see are going to be from the perspective of the parties, or normally from the defense in a criminal case. And I have seen plenty of cases where the witnesses themselves and their the effect the media has had on the trial. For example, cases where witnesses' names were exposed, at which point, the gangs that they're supposed to testify against, come try to do violence against them. There's plenty of those cases, but very rarely, I don't think I saw one. I have not seen one, a case where a witness actually files a motion or an appeal to not have to testify because the media is there.
So if we back off from the media a second and we just talk about witnesses not wanting to testify, does a witness have a right not to testify?
No.
Unless it's a Fifth Amendment right.
Yeah.
Right. But they can be subpoenaed, especially in criminal cases. It's a lot easier for the state to do this than other people, where we have literally seen witnesses in orange jumpsuits and cuffs sitting on the witness stand testifying because they have been compelled to testify, right? So a witness does not really have a right in a lot of situations to just ignore a subpoena.
Right. Sometimes they run and hide. And the judge will order the sheriff to go out there and find them, take them into custody, like you said, and drag them into the courtroom, or issue a warrant for their arrest because they didn't show up. It is in our system of justice, everybody has a right to everybody's testimony. And therefore, you cannot withhold your testimony. You have to come in. That trial has to be fair with all the evidence coming in. And the only way that can happen is if you compel witnesses and they have to show up.
Yeah, and I think and again, we've seen that happen in these cases, and that immediately makes the witness a little more adverse to whatever party, sent for them to get arrested and bring them in. But that is part of the process, and that makes this important. A lot of witnesses don't choose to be witnesses. They can be compelled to be witnesses, so there has to be some protections. And while you guys are saying that witnesses don't have rights, they actually do, because there's a lot of situations where a witness, and again, we can bring law enforcement into this, but I think, like you're saying, a gang witness, or if there's an informant or something like that, where some witnesses' names will be public record and they will be on witness lists and people can see them and the media can try to interview them. But in some situations, and we've seen it in Kohberger's case, where they've had a lot of these things sealed, and you can ask the court to have your identity, your name, your picture, wear a mask while you testify, different protections in place to protect your identity if there is a reason in the interest of justice. Now, it's not an absolute right. I can, if I'm a witness of a car accident and I saw the black car run the red light and hit the green car, they're not going to say, okay, Peter Tragos, because you think you're a big shot, you got to have your mask on, or you're a plaintiff's lawyer and you're actually testifying for the defendant that they were actually not at fault. So I can't say, I want to put a mask on and don't put my name out there because I don't want people to think I'm testifying for the defense. That's not a reasonable situation there. but there are situations where witnesses can have certain protections, right? And what are some of those?
Well, I think you made the distinction. It's not an absolute right, it's a protection. And if it's a matter of their safety, if it's a matter of the proceedings and the sanctity of the trial process, those are really the big reasons. There are also some statutory reasons. For example, children, victims of sex crimes, people like that. That's kind of the I would guess the groups of folks that have some sort of ability to ask the court to make an exception to the openness and the public nature of the trial, at least for their testimony.
There is a list that prosecutors have mostly, and that's a kind of a list that goes from extreme to not so extreme ways of protecting a witness. And it all depends on, again, the severity of the witness's problem. The mask you're talking about, that's a highly significant item, because that doesn't come up very often because it would violate some constitutional protections. And so you don't see the mask very often, but you do see anonymity where their name is not revealed. You do see the address is sealed so that their location or where they're living is not revealed. You do see those kinds of things, and you do see witness protection. We see it on TV a lot, but it really does exist that you have a witness protection program where they go into to protect themselves. So there's degrees of protection.
Right. And I think that the mask thing, we've seen it in a couple trials recently, even just one person specifically, and we've seen confrontation clause objections. We've seen jurors have a problem with it. Like, he's looking at me in the face. Why can't I look at him in the face? People want to see facial expressions. People feel like they can read body language. So there are issues with it. But going forward, and usually I save this till the end, but since we're talking about it now, going forward, because there's so much media attention on some of these cases, could you see a judge saying, we don't feel like it's that restrictive for the public not to see or hear a distorted voice of this witness if people in the room, the defendant, the lawyers, the jurors, the judge, can all see the witness and listen to the witness, but it's there's at least enough of a standard, right? So it doesn't rise to the level of needing to be masked, but it's not just there's no issues. There are some safety issues or whatever it may be, somewhere in the middle where they would say they're going to testify in open court, but as far as blasting it out there to the world and the public, we are going to protect these witnesses more. Do you think that's something that may be coming with more media attention, more cameras, more microphones in courtrooms?
Well, that is already happening. It is happening. And in fact, it takes courts a while to catch up with technology.
Always
and
behind.
And that's a real problem, is it does. It takes them a little while. But we're already now seeing where the judges are shutting the media down when certain witnesses are testifying. Cameras are off when this witness is testifying. So that you have some protections that are coming out, but it takes time for the courts to catch up with social media and with the technology, but it's happening.
So, Pete, do you think we could get to a point? A witness is forced to come testify by subpoena. Okay. Mm-hmm. Does that also mean they are forced to be on YouTube? They're forced to be on court TV and Law and Crime, and they're forced to have their face out there everywhere? Or can you see a situation where a witness would be able to opt out of that sort of thing, or ask the judge to say, I'm a witness, but I don't want any publicity off of this case. I think it's totally unfair that I happen to be here at some point in time, and now lawyers are going to be looking at me and saying this wasn't true. Body language experts are going to say I touch my face too much. I must be lying. Is that fair? Is that appropriate? Is that what we want in our judicial system?
Yeah, and I think you're right. The answer is yes. I think there's going to be a time and a place where there probably is going to be some form for every witness, and it's going to be a check the box. Do you have any objection to being presented on any YouTube channel? Yes. Do you have any objection
by the media, by the cameras,
whatever?
In the courtroom,
sure.
Period.
And I think that the courts and the judges take that stuff seriously, because the last thing you need is for some innocent witness, bystander, to have, like you said, the entirety of the media behind them as they walk to work every day and they're trying to sell widgets because in their store, and people are scrutinizing their testimony and say, I'm not going to buy anything from that guy because of the testimony he gave in so-and-so's trial. So I think it is more effective today than what our founding fathers thought of, 240, 50 years ago whenever the Constitution was drafted. But the reality is the system works because that openness does make witnesses recognize that their testimony is going to be out there. It will be scrutinized, and people will have an opportunity to evaluate what they said and how they said it. that's what makes the judicial process function.
So I think that's also an important point to always talk about when we do it, and we discuss it on podcasts, YouTube channels, why the utmost respect for lawyers most of the time, for judges, and always for lay witnesses, right? I don't like to comment on what they look like or what their dress looks like. It's like these people are just happen to be at a place and time and they're coming to testify, and to scrutinize them. Like, now, to think if what they're saying is not true or it doesn't line up with the other evidence, I think that's fair game. But again, I think it's very different to look at them. And Dad, in your situation, if you represented somebody that the public thought was a horrible person, and you had a witness who told you they are going to disappear, good luck finding them because they don't want this media attention and they won't do it if they can be on camera, what kind of motion do you think you could file? What kind of argument do you think you could say to a judge that would allow you some kind of protection from the media or from the cameras during trial that would also allow this witness to testify? And again, with all of our focus and context being, we're trying to create a situation where nobody's fair trial rights are violated, especially a criminal defendant's. And this would violate a criminal defendant's fair trial if they can't even call witnesses that are testifying on their behalf because of the media attention.
Well, you have a range. The most extreme range is you could actually ask the judge before the trial, if you know this guy's going to run, to take him into custody, because he can actually sit in jail pending the trial. You don't want that because he's probably a friendly witness, and he's not going to be a very friendly witness if you have him arrested.
Exactly.
But frankly, I've had that happen. I've had to do it.
And we've seen it in cases we've covered on YouTube where they turn into bad witnesses or pretty tough witnesses for whoever's calling them.
Right. And sometimes you have no choice. But you can do some things. One is you got to realize, again, as a defendant, you have, I guess, less authority than the U.S. government when you're trying a case. So getting in there and saying, I want to protect an undercover agent, well, everybody is going to buy that. But getting in there and saying, I've got to protect this particular witness. And if it's a kind of case, I believe it's Miami with the statistic I read, 75% of the gang trials in Miami have witness intimidation. And it comes in various forms, including, and I was again surprised to read this, emojis. Apparently there are emojis that come across social media, a gun to a person's head, things like this sent to a witness that intimidates that witness. So you've got to ask the judge, number one, no names, no addresses, it doesn't go out. Number two, turn off any photographs or any images of the witness while the witness is testifying. The problem you've got with that is you also got to make sure the witness is protected leaving and coming to the courthouse, because when they're out there and they leave the courthouse, they lose those protections. And they're going to get pictures and they're going to get photographs, and it's just going to blow the whole thing. So you've got to arrange for them to leave and come to the courthouse in some type of a manner so that they're not photographed. It's a very tough situation. That's a tough sell to the witness, honestly.
So what protections are in place after they testify too, Pete? Like I said, people can pick apart their testimony. They can say this and that. There can be reports in the newspaper. I mean, there always could have been. So do they have the same rights as far as defamation goes? Do they have any litigation privilege? Or is what they say in trial fair game? People can make a TikTok. They can make a meme. They can make jokes. They can make fun of them. They can break them down legitimately on YouTube channels. Is it just fair game once you testify at a public trial and it's been live streamed out to the world?
The general answer is yes, it's fair game because it's out there. Now, someone can't go in and defame them. And let's be clear about what defamation is. Making a false statement that is proven to be false that causes them some economic harm. You can't do that.
And that you knew was false, knew or should have known was false.
That's right. But 9 times out of 10, if reporters are reporting the way that media is supposed to do it, they're not making any statements. They're not saying the witness lied. What they'll say is the talking
feeling
heads
in the courtroom was this witness was not credible.
That's exactly right, which is an opinion, not a representation of fact. So the reality is, once they're out of that courtroom and once that case is over, there's really very little that the court, because there's no jurisdiction anymore, to be able to protect that person. And I think a lot of people, especially in very high-profile trials, wind up having that stigma for the rest of their lives. They were the ex-witness in that trial, and that's who they'll always be for the rest of their lives.
Yeah, and sometimes it works out for expert witnesses, but for other times it doesn't work out for expert witnesses. It can make a big difference.
Like if you could write a book, that's great. But
yeah, exactly. All right, let's switch gears and talk a little bit about sequestration. So a lot of people here, has the rule been invoked, and the rule of sequestration, which basically means witnesses can't sit in there and listen to other testimony. They can't get their testimony together to make sure it all lines up. They shouldn't change their testimony to fit with other witnesses on that side. Therefore, we send everybody out of the courtroom that's going to testify so that they come in and they independently testify to what they know, saw, or believe has happened. So it was easy back in the day. Now it's a lot harder. We saw in Johnny Depp's trial that somebody was on the stand, was accused of posting about the case, and the allegations around the posting may have been fishy, but when the judge asked her, have you seen any of this trial? And she said, yes, I've seen some clips of the trial. Well, she was booted off the stand as violating the rule of sequestration. So do you see this as a legitimate issue going forward, Dad, that these high profile cases that are all over TikTok and the news and your news channels, newspapers, whatever it may be, do you see this as a bigger issue going forward? And how are we going to deal with it?
It is a bigger issue. It is going to grow. Let's face it, look at social media. It grows exponentially, constantly. So it's going to grow. The problem that they're going to have is policing it. They're going to have a serious problem. This person, they admitted it.
Was honest, right?
Yeah, they're honest. But if she had lied and said, no, I haven't.
How do you prove?
How do you prove that somebody watched something on social media? How do you prove that's what they watched?
Well,
are we going to start subpoenaing all witnesses' devices and having an expert review all their devices before they testify to make sure they haven't seen anything? It's going to turn into a nightmare.
Well, let me ask you this. If that was the case, and you feel like you had reason to believe, and maybe you have somebody doing it, at the office, it's a big witness with a big Twitter profile, and they have liked some memes or video of a trial that you're handling, and you call them and you ask them if they've seen, you call them to the stand and you ask them if they had seen parts of the trial, and they say no, and you go lose. If you can prove that that wasn't true and they had watched the state's other witnesses before testifying, don't you think that's an appellate issue?
It's an appellate issue, but then proving that it impacted the jury verdict is going to be a different problem you're going to have. Did that lie make a difference?
Right, because appeals are for losers. What were you going to say, Pete?
Right.
Happened in Elizabeth Holmes. They were doing jury selection, and one of the jurors found out that another juror was basically going down their social media feed and was watching the news reports as the jurors were being picked. And they wound up striking certain jurors for having that social media exposure.
Yeah, and I think that is going to be something we're dealing with in the future, that it's even harder. And I think that's up to judges and lawyers to explain what it means and how you stay away from it. Mm-hmm. So there's two things I want to talk about with sequestration. Dad, what is the level that you believe somebody should be stricken as a witness as to what they see? If they see a meme that's like somebody's face going, I'm a liar, or whatever, versus actually watching testimony from the trial, is it anything they see on social media? Or do you think that there's a level of they have to actually see something that may or may not affect their testimony?
I think what you just said. I think it has to be something that may or may not affect their testimony. I think seeing a cartoon or seeing a headline doesn't necessarily mean it's going to affect their testimony. But yes, if they see somebody else's testimony, if they see a reporter that has reported on somebody's testimony and given opinions, or if they've seen somebody say, look, I know some outside evidence that's not coming in on this trial, but let me show you this. Yes, I do think that those kind of things could make a witness be stricken and therefore not testify.
Pete, what is the difference between an intentional violation of the rule and a negligent or accidental? What are the repercussions? What are the sanctions?
If it's intentional, meaning, let's just give you an example. The judge said, do not watch any social media that involves this case. And this person completely disregards it and goes searching for cases. That juror is potentially subject to sanctions by the court. They can be held in contempt. Now, if it's inadvertent, they walked out and they're checking their email and, a banner flashed up that said so-and-so in trial, the jury believes he's a liar. I'm just making it up. That's inadvertent. They didn't mean to do it. And most of the time, if a juror brings that to the court's attention, say, hey, judge, just so you know, I was checking my email during the lunch break, and this banner came up from some news organization I belong to, and it mentioned this case. The court's going to do a colloquy and say, all right, did that affect your ability to be fair and impartial in this case? No, not at all. Okay, fine. At least it's on the record. The lawyers don't have the chance to ask any follow-up questions they want, but you're not going to be sanctioned for something that you didn't do purposely.
Yeah, I don't know if they're necessarily going to ask if it affected your ability to be fair and impartial. I think they're going to ask the lawyers whether or not they think that they would still object to this witness testifying based on what they saw. But here, as we ponder that, and we're going to talk about it more, I haven't done this yet on a podcast. I hope it'll work audio-wise. So I'm going to put up on the screen in the Johnny Depp case, the situation where the witness was excused. I think it's just like a little bit of a 1-minute exchange here that we'll watch together. So whoever's watching the video will see it. But I think if you're just listening, you'll be able to hear the discussion between the judge and this witness and why and how she ends up getting excused and whether or not you think the judge did enough of a colloquy, because I don't think she really went as far as what you're saying, Pete, at least in this situation.
All right. Ms. Duders, I just had a question for you. Have you been watching the trial this past week?
I've seen clips of it online, yeah.
You've been watching, so you have seen parts of this trial?
Yeah.
Okay. And witness testimonies?
Yeah, I've seen clips of
You've seen it. Thanks. All right. Does anybody have any follow-up questions?
Ms. Duders, have you been watching?
It doesn't matter. She's been watching clips of witness testimony. All right. You're excused, ma'am. You can have your excuse.
Okay.
And that was it. I mean, this judge specifically said it doesn't matter. Nothing else matters. Now, maybe this lawyer agreed with you, Pete, and thinks, whoops. Sorry about that. Maybe this lawyer agrees with you, Pete, and wanted to ask some follow-up and say, well, if she didn't see anything that's relevant to her testimony, nothing affected her testimony, she shouldn't be excused. Judge felt like if you watched any of the clips, you should be excused. Do you think this is going to be something we're arguing about now?
I don't think that was far enough. Just because somebody saw something, unless, of course, this particular witness had been admonished prior to their testimony that they should avoid anything.
Well, I mean, yes, every witness was supposed to be, this is a civil trial, so the civil lawyers were instructed to tell their witnesses not to look at anything, especially as it grew. That was one of the problems. I think she was very honest. Maybe some of the other witnesses were not as honest, like we already talked about, but I think this is going to be an exact discussion that we're having now. High profile cases, stuff is literally everywhere. People feeling like it's a big complaint after this case. Amber Heard's lawyer said it was impossible for these witnesses and these jurors not to have seen what was going on in social media. So how do we deal with that? Should the bar be raised where if you see anything, you shouldn't be able to testify?
And as a judge, how do you unilaterally strike a party's witness? Because if it were me and I'm on the losing end of this thing.
Hold on. Just to correct that. Amber Heard's team objected and said that she made a post online about this trial. Now, it actually turned out that I think it was about another trial, but that's what kind of led this judge to say, oh, she's watching and posting about the trial. I'm going to ask her if she's watched. She says she's watched, and so she excused her.
If it were me, I think that's perfect grounds for cross-examination. I didn't hear enough, clearly, to let me know whether or not whatever she saw affected her testimony or potentially could have affected her testimony. But for cross-examination, question number one would be, you've been watching this trial. You were told not to watch this trial. And you, in fact, you're making posts about this trial on your social media. I would have used that as an opportunity for cross-examination. I don't know if I would have struck that witness based on what we just saw right there.
If you were the judge. If you were the other lawyer, you definitely try to strike him first.
Well, of course. Then I'd be like, Judge, what are we talking about? She saw the trial.
What do you think, Dad? Do you think the judge did enough there to excuse the witness?
No, I agree with Pete. I think the judge should have made some type of inquiry as to what she did see, whose testimony she saw. I mean, maybe she saw jury selection. I mean, what testimony she saw. One of the problems I think we have right now, and again, catching up, there's not enough case law guiding judges on what kind of inquiry you make on a social media disclosure like that. And I think that's going to come. But right now, it's probably going to be, the standard is going to be, and we all know, abuse of discretion. And so it's not going to get reversed for her striking because she did do something wrong. but I think there's going to come down the pike that there should be some kind of inquiry to see what she did and how it affected her testimony.
Yeah, no, I agree. And she needs to make a finding. Go ahead, Pete.
And I was going to say, and I don't put it on the judge because that's a civil trial, okay, not a criminal trial. I put it on the lawyers. The lawyers should have said, hold on, judge, I need to make a record. We're going to have to put the jury out, and I need to sit here and we need to do this colloquy so I have it on the record so we know exactly what she saw, what she did, and how it might have affected her. And that's a lawyer just, I don't want to say, I don't want to use lazy as in this particular case because I don't want to characterize these lawyers.
No,
But
the judge
lawyers
was
have gotta be
pretty
honest.
stern throughout the case. And she was making decisions and the lawyers were abiding by them. I think that's more of what it was.
Okay.
But I agree. I think they should have made a record potentially of that or a better record. But I think this is an example of today's day and age, how we're going to have to be dealing with it. What is enough? And if they admit seeing anything, is that just too much with how much media attention? I mean, Netflix made a documentary on it. There were so many eyes and so much attention on this trial that if she admits seeing clips, are we going to shed even more doubt on this trial as not having an effect based on the media attention and pressure? Because that's something that they were really fighting again in the post-trial interviews. And I think if they would have let her testify, the losing side would have been like, look, they let their witnesses violate the rule of sequestration and just continue to testify, even though she was watching clips. So I do think there is a bit of a hesitation there as well as the court and lawyers trying to deal with this, not allowing the media to have an effect on the outcome of a trial.
No, you're right. Clearly, you're right. But at the same time, the judge in this case unilaterally struck a party's witness. I don't know how important that witness was. I don't know what, the extent.
While you're saying
of her-
unilateral, the other side objected to her testifying. So it wasn't unilateral. It was
yeah, I
a
get it.
motion
One
made by
part-
the other side the judge granted.
Yeah, but and again, I didn't watch this trial. I've tried to avoid it because you were doing it all day long. The key is for me though, the lawyer didn't get the other side didn't get a chance to actually ask any follow-up questions. At least that's
Okay.
what it looked like to me. So anyway, the answer is yes. So it's going to become an issue in the future.
And then Dad, so with this, and again, not to say people are going to be untruthful or anything like that, but let's say a witness does not want to testify in a high profile case and they say, oops, I accidentally watched some of this on YouTube, therefore I can't testify. How do you think we're going to deal with that as lawyers that obviously want witnesses that have information to testify in cases?
Are you saying they did that deliberately to be excused from testifying?
Yeah. But how do you
Well,
prove that?
I think
How do you
that's
prove that,
contemptuous too. I think the judge could find him contempt for doing that, deliberately violating a court order in order to be excused so that not to give the testimony. The problem you've got is at that point, the jury, like people were saying, how important a witness is, the jury at that point isn't going to hear all the evidence. And we don't want trials like that.
Right.
So that's why judges can find people in contempt and maybe throw them in jail for 30 days for doing something like that. Because you just can't have people not giving their testimony to a jury to find, because a man's life is at stake in some cases, and you're going to have people that are going to avoid testifying by doing that. It doesn't make sense.
Right. And I think that that's also something that could lead to more gag orders. It's something that could lead to more closed off courtrooms and less cameras and less microphones if these types of situations are abused and become more of the norm versus the exception. And I think that's kind of part of how witnesses play such a key role in all of this is they are a big part of making a fair trial. That is how most of the testimony comes out in most of these cases. Is there anything either one of you want to add as far as, how witnesses affect the trial, how media affects witnesses, anything like that we haven't hit?
Well, there's another aspect to this is that if these witnesses watch a lot of TV and a lot of media, a lot of crime shows, those kind of things, they may not see something about this trial, but they'll see stuff that's going to affect their testimony. And so the media can affect their testimony because it affects their mindset. There's a study where there's a lot of studies on whether or not eyewitnesses really do see what they see. Well, they've shown where eyewitnesses who saw the studies doubt their own testimony, where eyewitnesses who haven't seen the media about that are sure that they can identify the guy. So those kind of things can affect the minds of witnesses.
I think there's going to come a point, and it's not here yet, but it's coming, where the courts are going to have to make a decision about what is media and what is entertainment. And at some point, they're going to have to draw the line, because so much of what we consume nowadays is, in a different medium than originally anticipated when the rules were put into play.
Yeah, I think that this is one of the scariest parts, because we don't want witnesses and jurors watching this stuff play out, getting influenced by the media, getting influenced by YouTube and TikTok and all this stuff. We really don't want that, because that is the way we ruin the fair trial system. That is how we end up with either no cameras and microphones in the courtroom, or sequestering every jury and every witness, which it just seems cruel and unusual. And again, all of this leads to a less fair judicial system, which is really what none of us want. But again, that's another one checked here with witnesses, and we'll continue to talk through this stuff. And what was the other one I told you we had? Have we done jurors yet?
We haven't done jurors.
Victims
We're going to do. Jurors we're going to do. Yes, we've got a couple more episodes left to try to hit every aspect of a fair trial and how it works. Maybe we'll do law enforcement officers or expert witnesses as well, and just how the media can affect them, and wrap that into an episode as well. But thank you so much for joining us. Dad, Pete, thanks for being here as well. Until next week, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast, featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.